Okay, we are officially at 2 minutes past, so I will go ahead and start. I want to welcome everyone. My name is Amy Krappel, and I am the director of UF's Jean Monnet Center of Excellence. The UF JMCE is funded by the European Commission's Erasmus Plus program and is also part of the JM in the US network of US-based Jean Monnet programs. A few housekeeping notes before we begin. Today's discussion will be recorded and available on the UF JMCE website. We will have a Q&A session following the presentation, and participants can submit questions through the Q&A button at the bottom of the screen. Please do not try to use the chat function. I want to thank everyone for joining us today to discuss the ethics of AI, EU and US approaches to the rapidly expanding use of AI. This panel is part of our JMCE series, The EU in the News, which examines pressing issues facing both the EU and the US, with topics ranging from the new pact on migration to gender inequality to our current discussion on the ethics of AI. Details on the other panels in the series and previous recordings can be found at the JMCE website, jmce.ufl.edu. I'm very happy to introduce today's panel, which includes Dr. Anne-Elisabeth Courrier, an associate professor in public law at the University of Nantes and a visiting fellow at the Center for Ethics, Emory University. She received her PhD in law at the University of Paris I, Panthéon-Sorbonne, and has had postdoctorate fellowships at the European University Institute in Florence and the Corvinus University in Budapest. Her research interests are centered on the relationship between law and ethics from a comparative perspective, with recent work focused on ethics and the law in social corporate responsibility, public governance, and most recently on big data and artificial intelligence with the European and American perspectives. Our second guest, more local, is Dr. Jasmine McNealy, an associate professor in the Department of Media Production, Management, and Technology at the University of Florida, where she studies information, communication, and technology with a view toward influencing law and policy. Her research focuses on privacy, online media, and communities. Dr. McNealy is also a senior fellow in tech policy with the Mozilla Foundation and a faculty associate at the Berkman Klein Center for Internet and Society. She holds a PhD in mass communications with an emphasis in media law and a JD from the University of Florida, as well as Bachelor's of Science degrees in both journalism and Afro-American studies from the University of Wisconsin. And our third panelist, Dr. Sandra Wachter, is a professor of technology and regulation at the Oxford Internet Institute at the University of Oxford, where she researches the legal and ethical implications of AI, big data, and robotics, as well as internet and platform regulation. Previously, Professor Wachter was a visiting professor at Harvard Law School, and she has also worked at the Royal Academy of Engineering and the Austrian Ministry of Health. She's also an affiliate and member at numerous institutions, including the Berkman Klein Center for Internet and Society, the World Economic Forum's Global Futures Council on Values, Ethics, and Innovation, UNESCO, and the World Bank's Task Force on the Access to Justice and Technology, to name a few of many. Her current research focuses on profiling, inferential analytics, explainable AI, algorithmic bias, diversity and fairness, as well as governmental surveillance, predictive policing, human rights online, and health tech and medical law. And today our discussion is moderated by Dr. Hannah Shaikh, an assistant professor in the Department of Gender, Sexuality, and Women's Studies, also at the University of Florida, where she also directs the Data Justice Lab. Her current book project, entitled Fractured Patterns, Space, Data, and the Search for Muslim Women, focuses on passive representations of Muslim women across time and space by datasets and archives. And with that, I am very happy to hand over the discussion to our moderator, Dr. Shaikh.
Hello, everyone. Good afternoon. Well, we're across different time zones. Good afternoon for those of you who it is afternoon right now, but welcome, everyone. And we will have the Q&A after. Please make sure to use the Q&A function at the bottom of the screen. And today we will begin our series of amazing presentations I'm extremely excited for with Dr. Wachter. Are you ready to begin, Dr. Wachter?
Yes, very
fantastic.
happy. If everything is working fine, you should be seeing my slide. Excellent. I get thumbs up. Yes, thank you so much for the introduction and most importantly, the invitation. My name is Sandra Wachter. I'm Professor of Technology and Regulation at the University of Oxford. I'm a lawyer by background, and I'm very excited to be talking about Europe's approach to regulation. I'm very lucky. I'm leading a research group here at Oxford that is called the Governance of Emerging Technologies. So I don't have to think about those difficult topics by myself. I have an amazing group of people who support me in this. Those are the folks that I'm currently working with. If anybody's interested in the work that we're doing, you can visit our webpage on the Governance of Emerging Technologies Research Group. Let's dive right in and talk a little bit about what Europe has in stock for AI and regulation. I'm going to be talking about the so-called conformity assessments and a little bit about the standardization process that is going on in Europe and two particular problems that are very close to my heart. Before I do all of that, I'm just going to have like a brief overview to tell you a little bit about the logic of the European approach for those who are not familiar with it. So Europe, as you know, probably has decided to regulate AI using the Artificial Intelligence Act that will come into force roughly in 2 years or so. It has recently passed, which is really, really exciting. And the easiest way to think about that framework is that it is a risk-based approach, very much a pyramid approach, if you will. The regulator decided that AI needs to be regulated according to the risks that AI poses. And we have at the top of the pyramid certain unacceptable risks that are going to be banned. That category of AI is very, very small. There are almost no applications of AI will be banned. Some applications of face recognition software and social credit scoring, those are some of the exceptions that will be banned, but the most of the applications will not. The meat of the whole regulation is in the high risk area, where the regulator decided that there are 8 different categories of where AI can be deployed and where it's very, very risky. It's allowed to use AI in those areas, but you have to follow certain ex ante regulations before you're allowed to put that system on the market. And then we have the minimal and low risk application. So as I said, the most interesting part about this particular framework are the so-called high risk applications. So if you're developing AI in one of the high risk areas, you have to follow certain rules. And so this includes AI that is used for education and employment, giving out loans, immigration, critical infrastructure, law enforcement. So those are the high risk areas that the legislator has decided are really, really important. And if you want to deploy AI in those areas and develop AI in those areas, you have to follow certain rules. So predominantly, this is based on transparency. So you have the obligation to follow certain risk assessment, you have to validate certain data, you have to document certain things, there has to be some whole human oversight, and you have to make sure that cybersecurity is in order, all of which is absolutely fine to do. This is the first part of the regulation. The second part of the regulation are the so-called harmonized standards. So the thing with the AI Act is that it doesn't actually tell you much in detail of what you're supposed to be doing. What will happen in the next 2 years is that standard setting bodies will create so-called harmonized standards that would flesh out what you're actually supposed to be doing. And that is not unusual for Europe. We very often do that. But there is a democratic problem that comes with that, because the standard setting bodies that are writing those regulations are predominantly led by industry. So the working parties that write those guidelines are predominantly people who work in private companies. And that doesn't necessarily need to be a problem. The issue is that in addition to that, the oversight about whether or not people follow those rules is also not ideal. This is done via the so-called conformity assessment. So conformity assessment means that developers of AI systems in high-risk areas will need to self-certify if they do believe that their systems that they have created themselves are legally compliant with those standards and with the AI Act in itself, right? And so that is a little bit of a problematic situation, because we are in a situation where those where companies are not only writing their own rules, they're also assessing if they believe that they follow their own rules. So this is the crux with the current AI Act. It is something that the legislator is actually aware of, which is quite interesting. There's an interesting recital in recital 64, where the regulator points towards the fact that an ideal situation would actually be that a third party makes that type of assessment. But unfortunately, nowhere else in the regulation is that topic picked up again. So there is no roadmap for us here to show or to initiate a path that would lead us towards such an assessment. And I think that's one of the biggest weak points that we have currently in that regulation. The second weak point that we have has to do with those so-called harmonized standards. As I said, there's the AI Act, and there is the harmonized standards that are supposed to flesh out certain requirements. The good news is that regulators are aware that bias is an issue. It's not something that is unheard of, but unfortunately, the way how it's being addressed is somewhat limited. If you look at the actual AI Act, there is Article 10 that very briefly talks about bias, but doesn't really tell you anything about how you should address it. So it tells you that you have to examine biases, but that is pretty much it. And this is, in fact, a big problem based on some of the research that we have done in the past. The good thing is that people are very aware that bias is a problem, and they have developed a lot of tests to actually test on how to figure out how problematic a system actually is. And so we have done some research around this, and we did a deep dive on figuring out whether those bias tests are actually legally compliant with European non-discrimination law. And so what we did is we looked at the bias toolkits that are currently offered, and we looked at 20 different bias tests there to figure out whether they actually live up to the standards of European non-discrimination law. And we came to the conclusion that most of them do not. So out of those 20, 13, so 2/3, do not live up to what Europe thinks is fair according to the law. One of the main reasons why this is the case is because most, if not all of those tools have been developed in the US, where the legal system is just very different. Non-discrimination law works very different. And so you are maybe in a situation where you want to do the right thing. You're a company, a public body that wants to test for bias, uses one of those tests and is not aware that you are actually venturing into a gray area, potentially breaking the law. And so that's really important to know, because the law in the AI Act doesn't tell you anything about that. And so that's a big loophole there. In response to that, we actually did some research and tried to figure out if something can be done about this. And we created our own bias test that is supposed to live up to the standards of what European non-discrimination law means according to the Court of Justice. So if there's somebody who's interested in this, this is a test that is called CDD, which means it lets you figure out if something is wrong with your system according to the thresholds that the court in Europe has developed. So the best way to think about it is as an alarm system that just goes off and tells you there is a problem there. So this is good for European researchers, but again, probably what we develop in Europe might not actually work in the US, because again, the legal system is very different. And so thinking about automating law in that sense is really problematic. But we have been quite successful with this in the past. A lot of public institutions have actually praised our work and have recommended it as a good way of testing bias. And recently, Amazon as well as IBM have implemented our test, which is really exciting to see. But this is the good news. The bad news is that those systems still have massive problems that the law does not pick up on. This leads me to a second piece of research that we have done, where we show the unfairness of fair machine learning. And so this has to do with the idea of how we actually measure bias and fairness, unfortunately. So imagine that you have a cancer detection software that has unequal accuracy rates. We'd say it has 90% accuracy for white people, but only 60% for Black people, which is unfortunately something that happens very often. So a mathematician, right, would say that the unfairness lies in those 30%. That is what is unfair. They would say that those two numbers should be equal. It should be equal accuracy across certain groups. So if you are a normal human being, you would say, like, bring them up to 90, bring them up to 100 if you can, make those numbers as equal as possible and as high as possible. So we have done some testing with the tests that are being used in public entire toolkits, and we have shown what they actually do is they level down. So what happens is that they don't bring up accuracy rates for everybody, they decrease it for everybody. Why are they doing that? Well, algorithms are actually just doing what you told them. You told them make two numbers equal, and that's what the algorithm is doing. It's doing it in the most efficient way possible, which is decreasing. It's much easier to decrease accuracy to increase accuracy. So the algorithm is actually just doing what you asked it to do. And again, this is a big, big problem because very often tech people don't talk to law people, and especially not for law people across the pond. And so systems are being developed that are actively harming people, which is really problematic here. Again, we have worked with the regulators here in the UK who are licensing medical devices, and they have actually said that they've been offered a lot of solutionism here, where promises are being made to make those systems more accurate for all groups, when in fact they're doing quite the opposite. So again, very little in the AI Act. Yes, it thinks about bias, but it doesn't think about what kind of bias tools are actually useful depending on the application and the sector. The last thing I just want to quickly talk about has to do with generative AI and harmonized standards. The European Union has decided to also regulate generative AI. And again, we think about this in terms of what the risks are. And I think one of the biggest risks that we actually see is a risk of hallucination. So if anybody's interested in this, we literally released that paper a couple of days ago where we did some investigations of hallucinations in large language models, and did ask ourselves the question, whether those systems should or could have a legal duty to tell the truth. And so some of the things that we have shown is that there are systemic problems with those systems. So this example that we have in the paper is we interacted with Bing a couple of months ago, and we did ask Bing why Boris Johnson was indicted. And so what happens is that Bing gives an immediate answer. It says Boris Johnson was indicted on 37 accounts of various crimes related to his conduct as former prime minister in the United Kingdom. And then it even gives you a source here. If you look at the source, it's the Financial Times. So you read this, it looks very well written, it looks very convincing. It even has a source attached to it. Financial Times is a repetition resource. But the issue is that that never happened. Boris Johnson was never indicted. If you look at the actual source, it pulls up the Financial Times article, and you see what the headline actually reads. It says that Trump was charged with 37 accounts. Boris Johnson just stood down from Parliament. So this is the conflation. You can see what happened there, how it hallucinated a fact that has nothing to do with reality. That's very dangerous, especially this year where we're in the year of super elections. And those systems are just spreading out those false accounts, and that's really, really problematic. The AI Act, unfortunately, doesn't really do anything about this, right? The regulation about AI, generative AI, doesn't think about hallucinations or misinformation or truthfulness in that sense, unfortunately. Most of it has to do with transparency and information along the value chain, questions of cybersecurity, red teaming. Those are issues that come to light. Information about energy consumptions, all good things, but nothing really about hallucinations and how it can spread unfactual truth across the internet. The only thing that we have is that there will be an obligation about watermarking. So that means that the outputs of a generative model need to be watermarked. So I can see that it has been created by an artificial agent. But that's only half of the problem, because they could tell you the truth, right? Just because something is artificially created doesn't mean it's wrong or right. It has no bearing on the truth in that matter. And unfortunately, the AI Act doesn't really do anything to deal with that. So in response to that, we actually published a paper a couple of months ago in November last year, where we try to play with this idea, because the AI Act doesn't really do anything, how we can use those systems to reduce the chances of hallucinations. And we are particularly interested in questions of subtle hallucinations. So that means not outrageously wrong things, but subtle things, where you can just see half-truths, if you will, because I think those are the more problematic ones. And so what we showed there in this paper and with the experiments we have done is that if you tell ChatGPT to write a paragraph about the General Data Protection Regulation, it does that, but it makes mistakes. Like it tells you that the only legal basis to obtain data is explicit consent. That's not true, but that's not completely true, is one of the possibilities of how you can get data. So it's a very subtle hallucination that you will only know about if you're familiar with data protection law. If you're just using it to write a short paragraph, it looks plausible and you might fall prey and again start spreading wrong information there. And so we came up with the idea of trying to use zero-shot translation to reduce the likelihood of hallucinations here. And what that means is that you are structuring prompts in a certain way that forces the model to only use information that you fed into it, rather than going back to the repository that they have and starting to hallucinate and make up things that don't actually exist. So it's a way of using this technology in a different way that forces it to rely on the input data rather than making up things for yourself. And if you do that, and we showed this in an experiment, it does that. So if you feed it accurate data and then tell it to use the information to write a paragraph about a GDPR, it does so, and it does so accurately. So that is a way of doing that. But again, the GDPR, the AI Act and the standards will have nothing like that in place. And that is the big issue, that very often we think about Europe as leading the way in terms of regulation, and in a certain way it is. But when it comes to the question when the rubber actually hits the ground, there's a lot of things that are actually missing. Yes, Europe is aware of bias, but there are no standards for bias. It's no coherent way of how to test for bias, how to mitigate bias. There's no awareness of the pros and cons about bias tests. Yes, there's awareness about systemic risk, and there's some regulation in place for generative AI, but hallucination is not a topic that was touched at all. And in addition to that, all the accountability mechanisms that we have are very weak, because they rely on the self-assessment of companies, which is one of the biggest points. So that's a rough overview that shows you a little bit how it works in Europe, and especially also showing you the weak points. I'm telling you this because I'm in the hope that at some point we will have a bigger conversation around that and maybe have the ability to adjust the framework. There are ways to do that, for example. And so having more awareness of what's broken and how to fix it could actually help to improve the law in the future. So yeah, that's roughly what I wanted to talk to you about, and very excited to hear your thoughts on this.
Fantastic. Thank you so much, Dr. Wachter. So much to think about. Dr. McNealy, are you ready to present?
I am, thank you. Let me just turn this on for you. So hello, everyone. Hope you can see the slides. I think you can. So I am here, I suppose, to give the US perspective related to artificial intelligence, policy, and ethics. And I generally want to focus on what's important for this conversation, especially for the United States. And there are a couple of issues that I think are really important. One, the United States, and this is probably the most important one, the United States is behind with respect to regulation, policy that provides an infrastructure for keeping systems like artificial intelligence and all of those other technologies that fall under the artificial intelligence umbrella in check, but also as it relates to enforcing the laws that we have now on the books that could possibly impact artificial intelligence. In my opinion, though, the important thing is that there is not a focus on the major important thing for artificial intelligence, and that is the data. The data is what's undergirding how artificial intelligence systems behave, the inferences that are provided in connection to these decision systems and algorithmic systems, the systems that have now started to, not started, but have consistently over the past couple of years, we've been looking at the impacts of these systems in our lives, whether it's healthcare, banking or finance, school admissions, even our, things we don't pay attention to, those recommender systems related to entertainment, which are included under those automated AI systems, which probably for the AI Act in Europe would be very low risk, right, systems. But they do have implications for things like culture, how we see ourselves, all those other things that are truly important. So I want to talk about what the important things are for the US in connection to both regulatory or legal statutory policy, but also the ethics and the applied ethics of thinking about those systems that we call AI or automated systems and how they are allowed to be used and the kinds of guidance and inferences that they are allowed to give and that are accepted by those systems. So what's the problem here? The problem is, one, in the United States, there is an overwhelming amount of data collection. And quite frankly, to a certain extent, unfettered data collection that happens with a lot of different systems. Now, we focus a lot on social media, we focus a lot on systems like Amazon, why they're in the news all the time. Amazon, Google, Meta, right? The FANG folks. But I would say that there are also other organizations, non-corporate organizations that are engaged in the collections of these huge volume of data. And that includes our government, and that includes civil society organizations as well. But this data collection has and continues to have unintended and unanticipated uses and therefore consequences. But also some of the problems with that are the error rates and the disparate impact. Dr. Wachter discussed that a bit in her presentation. And it's not low stake disparate impacts. These are both short-term and long-term disparate impacts for various communities. Now, when I say communities, people focus on things that we see a lot in the news, whether it's race, to a certain extent, language, but I would also add things like disability. I would add geography, right? In comparison with rural versus urban geography as well. But there are disparate impacts that are long-term, and we haven't even begun to see the impacts of some of the decisions and the inferences that are made in connection to these systems. And finally, and I'm gonna probably talk about this a lot more, and that is the lack of adequate policy in relation to these systems. So unanticipated data uses. When you think about a system of data collection, I want us to think more ecologically. It's not just one actor here, but there are a series of actors that work in concert, and data is used and connected to various other pools of data for inferences and decisions to be made about both individuals, about communities, about counties, states, and regions of the country, and the people who live there, people and organizations in them. It decides, or the decisions are made whether certain people are good risks for loans, whether they are a health risk, are they good risks for insurance, or what kind of insurance, what level of insurance. All of those are unanticipated data uses by the individual when it comes in connection with their personal or community level data. This is beyond the expectations of any individual of how they might be datafied in a certain way. And this leads to and has led to discrimination. I'm going to show some examples of the discriminatory uses in AI systems. Some of you probably recognize, others are just as bad. And quite frankly, over the past few years, there's not been a week that has gone by, especially in the United States, where we haven't encountered some news story regarding unanticipated consequences of AI or automated systems. And the question then becomes, what is the level of bias that is okay? That the law will say, this is okay. We'll accept this. We'll accept this certain amount of people being discriminated against. We'll accept, 25%, 10%, 5%. What is the percentage, perhaps, that we need to understand is an acceptable rate for a AI, usually system, to have these biased results for and the impacts that happen. So these are unanticipated data uses and impacts. And these impacts are disparate. Unanticipated inferences, whether it's, oh, this person is not who they say they are, so misidentification, not just they're not who they say they are, but they are someone that they're not. We've seen that quite a lot with respect to things like facial recognition and biometric technologies. Also, how biometric technologies, in addition, can make inferences about people with regard to health and other possible outcomes in connection to that biometric data. And those outcomes are disparate. We know, for example, and we've known for quite a while now, that facial recognition technology still is not that great, whereas prone to more error when a person looks more feminine and has darker skin. So on this spectrum of more error possibility or more error prone. And yet facial recognition technologies are still being used and deployed in various sectors, both public and private. And so the question again becomes, how much error shall we allow, both in the regulatory sense, but also thinking ethically? When we are an organization that wants to deploy a technology, what are we saying is our responsibility when we deploy technologies that we know there's research that has demonstrated that are prone to error related to significant portions of the population? So obviously, here's an example. Facial recognition software used to verify unemployment recipients reportedly doesn't work well. Note the date on this. So this is 2021 that this came out, and remember what was happening in 2021. This was perhaps the height of the pandemic with COVID-19. People were attempting to get unemployment verification so they could receive benefits related to unemployment, and there were systems deployed, AI system, but deployed, facial recognition deployed, that would say, oh, you can use this system to verify your identity for the state that had contracted with these organizations, and it would help verify you, and you can then get your benefits. What the problem was, they found that the error rate for these technologies was significant. So can you imagine attempting to get benefits during the pandemic, and you can't because a system says you're not who you say you are? So think about the delays, the possible consequences of a system saying who you are, but that system being erroneous for many, many people who had to use the system in various states that had deployed the use of the system. So that's a public use of and contracting with a private organization and having public impact in the use of these technologies. I also want to look at, you've seen this one too. This is from 2018. So a hiring tool that was supposed to be good, right? It's supposed to take out our human biases and allow AI to assist Amazon in this case. But there have been other organizations that have attempted to deploy similar systems. But the AI system, we forget, is programmed by humans, but also looks for patterns in data. And so if the pattern of your organization is already says one thing, then what is the AI being trained on? It's probably the same thing unless there is correction for it. So this Amazon AI hiring tool, it reportedly immediately started discriminating against women. But basically the outcome was that while you wanted the system to do better, it was doing basically the same as the pattern of the organization before. A third example, and this is in the health context, again, height of the pandemic. I'm showing these examples that are kind of like height of the pandemic because I'm looking at like consequences. It doesn't mean that since we're a little on the other side of COVID-19 that things are much better. They're not necessarily. And again, these stories are happening on a regular basis or being reported. Racial bias skews algorithms widely used to guide from heart surgery to birth. This is just one example. There are other examples of algorithms being deployed in transplant context, in critical care context, in medical funding context, that because of the error in how data is used, both as proxies for different things, but also as a way to the inferences from those data, there are disparate impacts that happening to particular communities. In this case, you had racial bias. There's also been examples, socioeconomic bias. There's been examples related to zip codes and all kinds of other things where the data has been the important structure that has made a difference. So where are we with respect to law and data? Because the federal law, there is no omnibus federal data protection act in the United States. The states, or at least some of the states, have taken up the slack. Here are like a list of some of the examples. There are obviously various other examples, but these are some of the well-known examples. The CCPA, that's California. People recognize it as being shaped after the EU's GDPR, but within a California context. Of course, you have Virginia's Data Protection Act, similar to, a little bit similar to California, and Colorado Privacy Act as well. These are all examples of how the states have stepped in again, but to protect people in their state though, right? And not necessarily people outside of those contexts. All of them have their great parts. Of course, the California CCPA amended not too long ago to include things like dark patterns, including algorithmic dark patterns as well. But there are limitations to what state law can do with regard to data and protecting people's personal data. Many of these laws also have thresholds for which they won't kick in until a platform, for example, serves a certain number of visitors or a certain number of people, which leaves a lot of organizations free to continue to behave in the data data collection that is at issue with a lot of this data collection and processing that is at issue in many of the things that I'm talking about. Where are we on the federal level? In the United States, again, we don't have a federal regulation related to data protection. We have, though, consumer protection laws, and we have consumer protection agencies, including the Federal Trade Commission. We look at anti-fraud and deception. again, at the regulatory level for regulatory agencies, and we have sector-specific data laws that are important for certain sectors. And of course, there's federal anti-discrimination laws, which are important when they are applied. What do we still need? Many things. So I want to show you just like some proposed solutions that have happened over the past 5 or so years. Algorithmic Accountability Act, the Data Accountability and Transparency Act, which was perhaps a proposal that was my favorite, perhaps, in this line of possible regulation. Of course, Algorithmic Justice and Online Transparency Act. And if you look at these, you'll see some of them have a lot of things in common, but many of those things in common are why they may not have been the best solution for what we're looking for with regard to data protection and uses of data, which include artificial intelligence. So Algorithmic Accountability Act, this was proposed in 2019. It would have allowed the Federal Trade Commission to make regulations and require impact assessment on high-risk systems. But the publication of the impact assessment would have been optional for an organization. The Data Act, which again, like I said, was my favorite, would have prohibited collection, use, sharing of personal data unless necessary. Do you know how much data that would have had covered had that law been passed Congress? A lot. It also had a focus on facial recognition technology and discriminatory use of data in places like housing, employment, and financial services. It would have required auditing, of course, but also that CEOs of organizations take responsibility by certifying the uses and audits that happen. Of course, it didn't really make it out of committee, unfortunately. And of course, this 2021, another example, Algorithmic Justice and Online Transparency Act, focused though on discrimination based on demographic and protected class status, protected class as interpreted by the US Constitution. And it would have required notices with plain language. It would have required organizations to have retained records for review and to make reports on things like content moderation, which has become a huge point of contention with respect to platforms that use algorithmic content moderation. And it would have established standards for safety and effectiveness. None of these passed Congress, and that's unfortunate. And we are still waiting on our federal omnibus legislation with regard to data protection, which can undergird policy related to artificial intelligence. We also, let me throw this in here as well, since we're talking about ethics, we also are sorely lacking with regard to consent and how we interpret consent, consenting to data collection just by use or continued use, and consenting to data collection with regard not just to the corporate sector, but also with our government sector as well. So with that, I turn back to the title of this, and that is Focus on What's Important. And to me, what's important for the US context is that we really need to focus on data and protecting from the discriminatory collection or the possible outcomes that are discriminatory, but unfettered collection of data and the use of it for various purposes that hurt individuals and communities. So with that, I thank you.
Fantastic. Thank you so much for outlining so many important questions for AI in the US context. I always learn so much from hearing you speak and your insight, Dr. McNealy. Thank you so much. Dr. Courrier, whenever you are ready, please begin.
Thank you so much. So I would like to share my screen as well. So I would like to speak to you about AI and governance and how to address the ethical issues rather than on the comparative perspective. My name is Dr. Courrier, and I am an associate professor in law in Nantes University, which is a university in the west part of France. And I am also currently based in Atlanta for the position of Director of the Online Education at the Center for Ethics at Emory University. I would like to introduce our topic today, saying that we are in a fascinating time. AI and big data are so powerful and offer so great opportunities for designing the shape of a new society, a society when we can make better decisions, better informed decisions. We could project more with more accuracy, focus on what is core to our lives. So in a way, I feel privileged to live in this era compared to other part of history, and play in a way the founding fathers or mothers of what comes next. At some point, I suppose there is a parallel to do with the new era launched by Gutenberg in the first under the first printer. The scope of this invention was very huge. It was a revolutionary impact. It was a new technology, and it is exactly what we are about to get. But as far as I can say, the impact here with AI and big data will reach a further scale. Indeed, the technology, and especially AI and big data, are able to take decisions on our behalf. And this has not been done in the past in history. They are able to take the decisions. I mean, we know how to do it. So the question is, if we know how to do it, should we let it do the decision on our behalf? And so this has consequences on our relationship to the machines, our relationship to the other humans at the professional level or in our family and relationship. Obviously, we will make new friends. We will have new relationship with the machine, with robots, with the AI systems. We may bond with an AI system, and it will have some replication and some impact on the human abilities. So living at the age of setting the first milestone, feeling like members of a community of founding fathers and mothers, obviously with this comes a full level of responsibility on the ways to design the rules and to frame the next society, to make sure that no one stay on the side of the road, and that the impact is positive, and positive for each and everyone. So a revolution, but a revolution with a full sense of responsibility. And so it's the reason why in EU or in the US, or we are speaking about the trustworthy systems. In Quebec, in Canada, with which I'm also working a lot, we are speaking about and we are using the word responsible innovation. And so we need to have this frame. The question I would like then to ask is whether regulation is able to capture or to catch the ethical challenges raised by AI and address these challenges efficiently. I like these pictures, this picture, because I mean, we could see that the net here is a kind of regulation, whereas the butterflies is the ethical challenges, each of them. And we are trying to get them and to capture through regulation in a way which is efficient or which might not be efficient. So this is a question I would like to ask. So that includes different types of questions. The first question I would like to ask is, what types of regulation are we looking for? And in a comparative perspective, it seems to me that we have a full range going from no regulation to hard regulation, and hard regulation with a court system. And so that means that in between, I mean, no regulation is the kind of thing that we may have in some countries. They say, no, actually, we prefer to focus on innovation and to let it go as it is. We will have the trust and the confidence in human beings to find a way. So we might take a generation, but we will be good. Or you could say, no, I mean, because of I mean, at least for for liability issues or for reputational risk, you need a self-regulation or you need a soft regulation. So self-regulation, like a code of conduct, in a company, soft regulation like a standard made in international organization or NGOs. Hard regulations are made rather in a country, and sometimes this is what we have seen adopted for not so long ago with the EUAI Act. And the hard regulation with a court system could go further and say we need also special courts dedicated their work to the regulation. Sometimes we also prefer the technical solution, and this is what we have seen and what we mentioned earlier. With some tests in bias, we are looking for the technical solution. We could think about it also in terms of differential privacy or ethics by design, privacy by design. These kind of things are really technical, meaning that sometimes they might combine also at different levels, but this is a full range of what we have at our disposal. So I mean that we, in order to make sure that we have a regulation which capture and address the ethical challenge, we might decide what type of regulation we need. But it also depends, and Dr. McNealy told us this a few minutes ago. We need also the types of context. And so there I would like to refer to the work done by Professor Hofstede, the 6D model of national culture, where he identified 6 very important driven forces to understand a culture. So whether the country is more keen to individualism or collectivism, what is the relationship between the power of the citizen? Are we more inclined to femininity or masculinity? Are we more inclined to avoid the uncertainty? And so are we more inclined to adaptability? What is our orientation? Do we prefer short-term solutions or long-term solutions? And do we take the time for it? And what is the level of indulgence? So the types of context might be very important to focus on in order to define what we want to do and how we want to make them, in a way which is applicable and practical for everyone. So, I'm French, but I have spent a lot of times in other countries, in England, in Hungary, in France, and 7 years in the States. And something struck me regarding the freedom and the concept of freedom in public spaces. In France, if I am a French citizen, I want to go from my home to the street. I have what we called in French the freedom of circulation, meaning that I am allowed and I can move wherever I want. So that means that in terms of facial recognition technology, it is an issue. Camera surveillance is an issue because it impedes and it breaches my freedom of circulation. Whereas in the States, everything is really private, and we have the full concept of privacy within the home, right? And so when we go out, it's public. So meaning that we have a surveillance by camera or not, it's not so important. So we are always speaking about the friendship, which is true between the US and the French countries, right? So even between these two countries, we have some differences in terms of the way we conceived the concept. So having them in mind is very important to see whether and how we can address the question of the regulation of the ethical challenges of AI. Another type of answers that we have to look then is the types of answers that we are trying to see. So just to summarize what has been, it's not a summary, it cannot be a summary, but to reflect on what has been said by my colleagues here. In the EU, we have a full regulation which has been adopted a few weeks ago with the pyramid of risk, and I want to go deeper on that. And in the US, we have seen the adoption of the AI risk management framework with some executive orders. We spoke about the proposition which were made at the Congress, but which has not been adopted, as you mentioned, Dr. Neely. And we have also some state laws, obviously. all the three possibilities. I mean, I didn't mention Canada, but Canada is really focusing right now on a debate about the AI and Data Act, the ADA, and so which is also based on the risk approach. So all of the three systems here are really based on the risk. But as we said with Professor Wachter, we don't have some issues with the EU AI Act are not fully covered. So especially the questions of the liability, not yet. Meaning that we are still discussing another directive on the liability issues. The same regarding the generative AI or regarding bias. Regarding bias, I found very interesting that in Canada, what they suggest, it has not been adopted, but it is currently under discussion, is that, they say that actually the question is a question of the harm. And so we would go back to something like a tort law, which would be then adjusted and adapted to a specific context. But we have the way to do the transitions between what has been done before and the way we approach the new technology. So the types of answers are very important, and it implies different types of actions, meaning that in the EU, the tendency will be more a regulatory type of action. In the US, it will be more a consensual type of answer, consensual and voluntary, but meaning that we are always reviewing it on a yearly basis, 2 yearly basis. It's something that we look forward to it. In Canada, it is an approach which is really practical and which is, for this reason, very interesting because it brings a solution, especially for the stakeholders. This is something I suppose we need to have in mind. So different types of regulation, different types of context, different types of answers, and so different types of action. And we need then to look at the international initiatives as well, which are blooming. So obviously I don't have all of them, but we have already, just to mention a few, the OECD, who did a lot regarding the classification of the AI systems. The Global Partnership on AI, which is a very interesting proposition to me, especially because they give the positions they have, they give and they give a way for the stakeholders to raise their voice. So, for example, they have representatives for civil organization, international organization, NGOs. And so meaning that it is not, compared to the UN, it's not a model where we are focusing just on the representative of the state. We have representative of the state, but we have also different types of stakeholders who are experts in the matter and could help us shape and design the diversity we need to tackle the AI ethical challenges. We have also a lot of initiatives coming from the UNESCO, especially on AI and big data, and the way we are helping the states and the member states to help with ethics of AI. And so, as just mentioned, the UN, which for the first time adopted a resolution last week or 2 weeks ago. So a lot of activities there, meaning that at some point, I don't have a full answer, but I have some convictions. It seems to me that we have and we need some principles adopted considering the context by some regions in the world. The principles should be adopted through law by a parliament or by an assembly. But I have a feeling that even if I have a law background, law will always be catching up and running behind. AI is going too fast. So it's not enough. We need to have a court or quasi-judicial system in ways to make sure that the questions of the liability is taken seriously. Even if it's not the only way to do that, and to make sure that we are liable and not just or accountable and not just responsible. meaning that we need at some point with all these different blooming initiatives from national perspective or international perspectives, seeing that we have some crossing issues which are similar. We are all speaking about privacy. We focused today about bias and fairness. We have the question of the transparency, which is quite addressed. We didn't mention the question about digital sovereignty, but we should. And so meaning that at some point, I suppose that in 1 or 2 generations, we will be able to have a body of law which will be settled and that will be adjustable. And I mean that we will have a frame actually for the world. But in addition to that, that means that for the moment, we need to think. We need to think about the interaction of the AI regulatory systems, what we call the regulatory interoperability systems. This is something we have to think about, and we have to think about education as well. We need, even if we have the principle adopted by a parliament, we need to focus on education and to educate everyone about the awareness of the ethical issues on AI. It's the reason why actually we did at Emory with the continuing education a program on responsible AI, the ethical strategies for your organization. It's a 6 weeks courses online, asynchronous with videos and reading a list and assignments. And I mean, the idea is really to develop it in a way that could reach out to everyone who could be interested in it. And I would like to thank you for your attention.
Fantastic. Thank you so much. We have had 3 amazing sets of speakers, and I am very, very excited to share some of the fantastic questions we've been receiving from our attendees. But I'd like to start out with a question that I have. I'm extremely excited to be a part of this space. So I've seen from the news coverage of the AI Act passing that there's a lot of conversation, even in the news coverage of it, that the AI Act's regulations can stifle innovation. So I know that Dr. Courrier mentioned that the idea of no regulation can be seen as supporting innovation. So I'd love to hear from all of you about the claim that regulations such as the EU AI Act or the potential passing of a congressional bill, or maybe that executive order having some teeth put into it, stifle innovation. So please, I'd love to hear from you.
Yeah, I'm happy to start this because I guess like Europe is leading the charge in terms of regulation. I think it's a very dangerous and untrue narrative that completely misunderstands regulation. And it's a very boring argument that always comes up as soon as there's any type of regulation. People say, oh my God, this will stifle innovation. It stifles bad innovation, and that's a good thing. Like nothing in the AI Act is there where I would say that's unreasonable. Examining biases, good. Making sure things are transparent, great. Making sure systems are not opaque and explainable, fantastic. So it's banning opaque, racist applications. It's hindering that type of innovation. It's stifling sexist, ableist, harmful innovation. Fantastic. That's exactly what it's supposed to be doing. So I'm not quite sure who is losing out if we are not following those rules. And that's the problematic narrative that always comes up. It's stifling innovation. Yeah, it's stifling bad innovation. And again, I've compared this very often to the automobile industry, and others have as well, right? When first laws were introduced that said you have to have safety belts and airbags, also people were screaming, that's my freedom, that's stifling innovation. And who is getting in a car that doesn't have an airbag or a brake anymore? No one, right? And so people want safe cars, safe planes, safe trains, safe bridges. And all of that is regulated for a good reason. So it's stifling harmful and problematic innovation. And it's making sure that we can enjoy technology in a meaningful way. So no, I would disagree with that. It's not stifling good innovation. It's just holding back the bad that could come from it.
I would agree with that. We have had several decades of consumer protection and product liability law in the United States, and you know what that has done? It has helped us be more safe. It is tamped down on some low-hanging fruit harms, like things that could easily be remedied by organizations if they had the correct incentives, the incentives being law and liability for harms to people. Like the question of just allowing harm that we recognize to people just because it's innovative is mind-boggling to me. We know, we have several years of research from independent actors, from government actors, from corporate actors themselves, quite frankly, regarding many of the systems that we're talking about. And yet it's like, oh, but if we regulate, it's bad. Are you serious with that question? And can we be really serious? Organizations that are regulated do not stop innovating. They just find better innovations, right? They come up with different ways of innovating. They get smarter, or at least they put out the research that's a little more complex, that takes a little more for them to put out or to make sure is not harming people, but they don't stop innovating at all. At all. In fact, they probably make more money not harming people than with the easy innovation. So I think, yeah, we need to stop with that.
If I may, I would like to say that it's exactly what the government have in mind, and the international organization as well. I suppose no one wants to take the responsibility of saying, hey, go just for innovation, right? I mean, it's the reason why in the US government or in the EU government, the first wording was trustworthy AI. It's the reason why in Canada we have the concept of responsible innovation, not just innovation, but responsible innovation. So then the question is, I mean, and so to go back to what Professor Wachter was saying, obviously we need to have some kind of safety. We all look for it. And again, it might be also, even if it's not on the political agenda, it is a way to have and to develop what the Canadian called the social acceptability of AI. You have to mention it anyway. So then obviously, I mean, you could say, let's mention it, but not apply it, right? And so we need to have it apply, and we need to have regulations. But then the question is what level of regulations, and where to go with the regulation, and for what kind of is it really a system which is applicable for the businesses, for the corporation? What tools do we have really ready as a toolkit right now with the EU AI Act? I'm not sure that we have the answers, but we don't have the answer neither in the US, and we don't have the answer in Canada. So it seems to me that really to answer the question you were asking is we need time. And it's a question I mentioned twice, I think, the question of generation. We need, I suppose, a full generation to settle this question at least.
Fantastic. Thank you all so much for your clear answers, such fantastically clear answers. So this is a question from one of our attendees, and it's a huge question. So please feel free to take a little piece of it and offer an answer. So what are the main hindrances to AI regulation in the US?
I think there are several hindrances to AI regulation in the United States. One is lobbying, and lobbying by platform organizations, other tech organizations, even civil society organizations, that lobbying influences our policymakers. It's unfortunate that even when we have had hearings, and those very public hearings, the outcomes haven't quite made dents in things like data protection, and now artificial intelligence. So that's perhaps one of the largest, but also just like political will to get this done. Of course, we've had several decades of knowing that we needed something, regarding data, how we are allowing data collection and data use, and nothing has happened. There have been proposals at the federal level. Again, I showed you 3 possible laws related to data protection and artificial intelligence, but there have been several proposals, many in various years having multiple, and they have not gotten out of committee. And so that demonstrates there's some like dysfunction, dare we say dysfunction in Congress with regard to data and how it's used. And I would also note that this is post 9/11 and access to critical data about individuals and organizations and communities. And so it's not just, again, I want to make clear, it's not just corporate organizations, it's how our government collects data. And there's symbiotic relationships between our government and data collecting organizations, and we need to recognize that. So there's a couple of things that are in the way of adequate regulation at the federal level with regard to artificial intelligence and data protection. It starts in Congress. And so that's what we need to focus on.
If I may, I would like to reverse the question. What would push finally the US government or the stakeholders, businesses, to adopt a responsible AI attitude or behavior? I suppose at the end of the day, it's all about reputation. It's going. I mean, it's a question of speed. It's faster than the law, than the trial. It's cheaper in a way. I mean, you cannot afford it anyway. So the question of the reputation is crucial to the development. So at some point, either we do it with a regulation at the federal level, but I'm not sure. I mean, there is a question of culture here, and it's the reason why I'm going back to what Professor Hofstede did in the Netherlands. How do we shape? How do we understand and feed ourselves from the context? That's very important.
Yeah, just one sentence to this, because yeah, I agree that the lobbying effort is definitely a big issue, but just to say, Europe is not doing much better, in the sense that we are also subject to high lobbying efforts, and if you have followed the adoption of the AI Act the last couple of months, it almost completely failed. Because certain countries were influenced by industry players and they were pushing very much towards the finish line to kill the whole thing. Thankfully, that didn't happen, but we're not immune to those things either. And so I think just thinking about what that means for regulation going forward on a global scale, if we know that nobody is immune to those influences anymore, I think will be really, really, really important.
Fantastic. Yes, thank you so much. Such important answers. I will definitely use this recording in my future classes as well. It's extremely important answers. So here's a question from me. I'm sorry to upend the amazing audience questions we're receiving as well, but I'm really curious to hear you all answer. If you were to place something in the unacceptable risk category for the EU AI Act that doesn't already exist there, what would you place there?
Yeah, I'm very happy to start this. I think everything that is in there belongs there. I just think that the exceptions to the rules are gaping and cause a big problem. So it's often portrayed as Europe is banning so many things, but it's really not. Like, it's actually curious that we call it a ban if the list of exceptions is as long as my arm. So it's kind of just regulation. And so I think that's really important to keep in mind. So when we talk about face recognition software, I was a very strong advocate to make sure that that's not used in public spaces for criminal investigation for a host of reasons. We can also have another webinar where that's a problem in itself. That didn't go through, so it's still allowed to use it like for criminal justice purposes. I would have liked to seen a ban there for that purposes. I would have liked to seen a ban for predictive policing for similar reasons. It's still allowed to do. We can still do it in a way, again with exceptions, but it's a faulty technology, so there's no saving there. I would have liked to seen a complete ban on emotion recognition software in high-risk areas, which we banned in education and in the workplace, but not for immigration and not for criminal justice. So again, you can see where the exceptions come up. They're always in certain areas, which is a really big problem. So I think I would have liked to seen a more extensive ban in those areas. I think we fell short there.
I would say that, I mean, obviously, when we discuss in a US context, having this list of prohibited risks is something that is, I mean, that takes by surprise. You said, what? So meaning that we have to acknowledge this difference, even if we disagree with it. The question of the scoring system is something which is very important to me. And I've been very surprised to see that no regulation has been taken at the federal level by the US government, but a lot of states have already taking action, or even if it's not the state themselves. So meaning that it would be some federal agencies have taken action against scoring systems in housing, in hiring questions, or so meaning that there is an awareness, there is an action taken, even if we don't have a regulation again. And that's good to see. That's good to know.
Absolutely. Would you like to add something, Dr. McNealy?
So I agree with both of these answers, but I don't know about the unacceptable risk, but I would say high risk. And I'm going to say something a little controversial, and I would put under high risk entertainment systems that provide recommendations. These are cultural exchange systems. And inherently within those, there is scoring in connection to culture. What culture matters the most? What kind of content should you be seeing, or that you should be interested in, not that you necessarily really are? And that has huge implications for culture. I'm going to say the word imperialism, right? In a technological framework regarding content related to what's good, what's bad, what's acceptable, what's high art, what's not high art, right? And we don't necessarily think of that because we think of high stakes things like criminal justice, banking, immigration, even. But how we view ourselves is perhaps just as important. What we think of as important, who we think of or value is important too. So I don't know. I would say like some of these systems that we think are low stakes perhaps need a reevaluation because of their impacts. I mean, as a scholar in a college of mass communication, we've had years and years and years of discussion on media effects. And so to ignore that, I think, is to our peril. There's a lot of scholars in what we call the global South who are writing about the impacts of recommendation systems with respect to culture and how these make culture in a certain way. And so we really need to pay attention to those kinds of impacts as well.
Can I just quickly say to this, because I fully agree, I could not agree more. And there was actually discussion of making that a high-risk category. So the European Parliament last year in June proposed to make exactly that type of recommendation system a high-risk category, but it was taken out towards the end again, coming back to the earlier point of lobbying. So there was actually awareness about this, but unfortunately did not make it through a finish line.
Thank you so much. Again, really fantastic answers. Thank you. So we just received a question that actually speaks to Global South. And I feel like as somebody who works on data infrastructures in the Global South, I would also love to hear your answers to this question. So how can countries in the Global South maintain respect for their citizens' fundamental rights and safety while facing limited capacity in controlling AI technology due to a shortage of skilled manpower and infrastructure? How do these nations navigate the AI race under these circumstances? It's a tough question. It's a tough question.
Yeah, I think that's a really tough question, but I want to point to some examples over the past few years which may be instructive. One of those deals with WorldCoin, that in the Kenyan context, where the country of Kenya said, wait a minute, we're going to time this out because we're dealing with our folks' fundamental rights and safeties in regard to this currency, but also with regard to, again, the data in connection with that currency. And I see more and more countries similarly responding to how labor is being treated by these organizations and the datification of laborers in connection to working for, whether it's in content moderation, labeling of content as well. But I see more and more countries in the Global South attempting to assert the rights of human rights of their citizens and folks within their boundaries in connection to these AI and algorithmically related systems that external organizations have parachuted in an attempt to exploit and extract from them. I think it's really important that countries of the Global South continue to assert their sovereignty with regard to their citizens and the rights of their citizens. And even if it comes as a shocking blow to non-central organizations that attempt to come in and use labor, use data, use land, quite frankly, as well, and resources, that it'll be really important for Global South countries, but all countries, quite frankly, to really recognize the rights of their citizens and the people within their borders, quite frankly, with regard to how these technologies can impact people.
I would like to say that it seems to me that it's in 2 or 3 steps. I don't have a recipe here, but it seems to me that the first step is to reach out and to get recognition on the global organization. And I'm coming back to the Global Partnership on AI again, because they have raised the question already a lot, specifically in regards to Africa, the countries coming from Africa. And so we have some and there are some research in residence working on these particular questions. Then the question is the training, and we know that some in Africa. I'm taking this point because I know this one more. Training is on its way, and we have the question of the training anyway in all the countries for all the citizens. This is a question we have to about education. Then the question of the concepts is more difficult to approach. And so the concept of privacy, concept of transparency, concepts of bias and fairness might be different. And so this is where we really need to stop our and to listen to the positions of these stakeholders and countries. So, I mean, this would be my answer right now.
Fantastic, fantastic. Thank you so much. Dr. Wachter, would you like to say something before we have some concluding thoughts
Yeah,
and
just
messages from everyone?
again, there's no disagreement. Very boring webinar. Nobody's disagreeing with each other. But full-heartedly agree with everything that was said. I think there is really a need to understand that data doesn't grow on trees. It's not that you go into the forest and you plug it from a tree. It is a resource that is being taken away elsewhere. It needs water, it needs land, it needs electricity, it needs an immense amount of resources. It is being powered by what's called ghost workers, because you don't see actually who is behind that ChatGPT interface that is being presented to you. You don't actually know, like it's being hidden. But there are people that have a job that is emotionally straining, extremely hard to do, a job that probably no human being should actually have, being paid $2 a day to do a task that no human being should be subjected to. Yet the technology that is being created there and sourced there doesn't even benefit them because it works very bad for their communities. So it's environmental racism in that sense, right? You're going to a place, you're extracting the labor, you're extracting the resources, you're building systems, and it doesn't even benefit those communities. In fact, those are the communities that are most discriminated by those systems. And that is really crucial for us to think about is it ethical to use that? Right? Is it okay to use those systems for all kinds of applications if I know where it came from? Like, is that actually ethical? Or should we think about different ways of governing this? Again, compare it to fair trade products. When you go into a supermarket, when you know there is an ecosystem behind it that is responsible. Should we not think about that type of regulation going forward to make sure that it's being sourced and created in a way that is sustainable and respectful and protects and values human rights? And that is a topic that is not discussed at all because it's called in the cloud and the new gold and the new oil and like how exciting it is. But nobody talks about the human and environmental cost that is behind those things. And I think that's really important. We should not shy away from that anymore to make sure that there is a cost, a human and societal cost in creating those systems.
Thank you so much. Thank you so much. So we are unfortunately at time, but I would like to communicate to all the attendees that a brief survey will pop up as you're leaving the webinar. Please complete the survey. And we are at time. I'd love to hear concluding thoughts from everyone, but it is 1:30. Well, how do we
Maybe
do
just
this?
a quick 1 minute, if there's anything you want to add,
minute.
and I will add my thank yous to everyone now.
Sure.
So just a final word in reverse order, because we ought to change things up every once in a while.
Let's
So
do it.
Dr. Courrier?
I would like to say that, I mean, it's great that we all share the same questions. I mean, to answer a question, we need to have to identify the question first. And we all share the same concerns about the question regarding responsibility and trustworthy systems. Then the answer is different, and we have to, I suppose it's good to know that. I'm really looking forward and counting on the time element, on the time variable, to find something and to fix the thing through time.
Great. So going again in reverse order, Dr. McNealy?
Yeah, so I'm grateful to have been on this panel with all of you to have this important continuing discussion regarding artificial intelligence and the technologies related, and of course the data that undergirds it. I would hope in the future we continue to have these discussions, but move from discussion, hopefully folks in the audience move from discussion to like application of some of the concepts and the things that we've been talking about, and especially to consider what Dr. Sheikh focuses on, and that is the impacts of on the global South, and even the global South within the global North, as it is important as well. So thank you.
Yeah, I'm very grateful that I was able to be here and have that type of conversation. It doesn't happen enough that we talk to other communities in our jurisdictions. And it's very easy to say, oh, we agree on good AI and fair AI and ethical AI. But what does that actually mean? And you actually only learn what it means when you talk to somebody that is not you or very like close in your little bubble, and you actually branch out and talk to people about this a bit more in detail. So I've learned a lot, and I'm still learning a lot. So I'm very, very grateful for all the things that I don't know. So very grateful for fellow panelists as well to learn something that I didn't know before. So thank you for that.
Okay, so I want to also thank our moderator, Dr. Sheikh, for your contributions and for agreeing to serve in this capacity. Thanks to our erstwhile panel participants, a few of whom have endured for the full length. So thanks to all, and I hope everyone has a lovely evening or a lovely afternoon. And again, the recording for this will, sooner or later, be available on the JMCE website, and we will be letting folks know when that's available. Okay, bye everyone.